Swayam Prabha. Digital India. Educated India.
Dear students, and in this class we are going to discuss mainly the US jurisprudence on various interface between intellectual property rights and competition law. And today's class is specifically we are going to discuss the tying arrangements and intellectual property under the Sharman Act, and within this class we will see the tying the intellectual property is interfacing in the case of tying of technology with more than one product, then licensing provisions, and then block booking, then copyright and softwares, and how the intellectual property softwares is mingling with competition law, then trademark and tying. So, basically the interface of tying, and we will see along with all these specifically these points. And tying agreement, in the last classes which we saw, that tying agreement is nothing but the two products, one is the tying products and the second one is the tied products. Any company try to sell these two products at a time compulsorily on the consumers. These tying agreements include get back provisions, and then restrictions on resale of patented products, and this tying can be in the nature of restrictions on licensees ability to sell the unpatented product. So, the patented product is tied with an unpatented product. Then again licensees entering into future license with other patentees, then mandatory packaging licensing along with the patents, then royalty provisions to collect royalty on the sale of unpatented products, resale price restrictions, all these we can see come under the purview of tying. And we will see today and the case laws from the US on this tying intellectual property, how these intellectual property rights interact with the competition law through the cases, famous cases come before the different courts in the US. As we already said that the tying arrangements, tie-in arrangements or sale on condition of taking another product all violate antitrust laws. And in tying agreements, actually the seller agrees to sell a highly usable product along with not so important product, or on the condition that he will produce or give a service, the buyer will purchase a less important product or less important marketable product. And you can see that this is actually a burden on the consumers. He want to purchase only one product, but the seller says he will only give that particular product if you purchase the tied product, which is an unwanted product. The antitrust laws always consider this as tying agreements as a violation of antitrust laws. In the case of Northern Impact Railway Company versus United States, it said that the tying is unlawful under the Sharman Act as well as the Clayton Act, the provisions of Sharman Act and Clayton Act. And you can hear is clearly we can see that the patent holders compel the customers to agree to a purchase on unpatented products along with their patented product. Actually, in Henry versus A.B. Dick, in this particular case, the court said that this is okay. If one product is useful along with another product, and this is allowed, but the Clayton amendment is to come to overrule this Henry case, and the Clayton Act amended and overruled this particular decision and said that tying is illegal, tying is violation of the antitrust laws. Again, the teledirect case, the Canada is one of the most discussed tying cases in Canada. It was alleged that selective refusals by the respondent to license its trademark constituted an abuse of dominant position. So, but here also the refusal, the court sometimes said that the refusal to license is within the legal bounds, and you have to look into the circumstances, how the circumstances under which one product you are selling along with another product. So, there is a lot of confusion in the earlier times that whether the tying, the one product is tied with another product is good or bad for the consumers. So, we will see it from the different cases. First of all, if we look into the tying, the concept, tying of concept, definitely a patented product, a very useful product is always tied with a not much important product or non-usable product. If sometimes the consumers want only the first product, but they does not want the second product. And here it occurs when the tying product is patented and the tied product is unpatented, but the tying product and the sale of patented products is conditioned. So, the sale of the patented product is conditioned on the purchase of an unpatented product. Here the circumstance is something different. If the two products are useful, then the scenario is absolutely different, but if one product is forced on the consumers, then the circumstances are different. So, we have to look into these circumstances through the different cases. So, here in the case of, it can be products, it can be services, and also this is one of the famous cases. We will start with the Microsoft case. The Microsoft in the earlier times, and they tied their Microsoft media player along with the Windows. In the US jurisdiction as well as in the European jurisdiction, the competition authorities held that the tying of Windows products with the Windows media player is violation of the competition provisions. Here you can see that sometimes the sellers bundle one product with other or service, the product plus service or product plus product, all these will come under the purview of the bundling. And here the consumers are not allowed to purchase one product alone or purchase the product or not availing the services. It is problematic. So, here we can see that the goods are sold separately. If it is in combination, goods plus services, it will come under the purview, it will come under the definition of tying. In a mixed bundling, so you can see that the goods are tied with the goods are tied with packages, goods are tied with services. So, this can also be come under the definition of tying. And one of the famous cases is the Eastman Kodak and Company versus Image Technical Services. This is the 1992 case, one of the famous cases on tying. And here Eastman Kodak at that point of time is a well known company in all photographic goods at that point of time. Here you can see that Eastman Kodak always conditioning their all licenses are one or more items of intellectual property and the licensee's purchase of another item of intellectual property or goods, service. So, in this particular case it was held illegal or illegal per se. So, it is illegal tying. So, the Eastman Kodak's the defense was that increasing efficiency and competitive benefits. So, if tying of one product with another increases efficiency in the market, then the scenario is different. But it is the duty of the seller to prove that how it increases the efficiency and how it is the competitive effects or competitive benefits in the market. It is the duty of the seller to prove that these are beneficial and pro competitive in the markets, then the scenario will be different. So, when you tie one product with another product, you have to fulfill certain conditions. Here the seller has a market power in the tying product. If there is no market power, then it will not come under the point of view of tying. And the second condition is that the arrangement has adverse effect on competition in the market, and also with the tied product. So, if there is no adverse effect on the market, then the competition provisions will not attract. Thirdly, the efficiency justification. I already talked about market efficiency. The efficiency means the market efficiency. If the tied product and the tying product is going to increase the efficiency in the market, increase the competition, then it will not come under the purview of tying, or it outweighed the anti competitive effects. So, it means that if the efficiency justification outweighs the anti competitive effects, then it is allowed in the market. So, again, but the competition authorities and agencies always presume different intellectual properties confers market power upon the owner. So, that is the first condition, market power of the tying product. If the market power is not proved, then tying cannot be proved. That is the condition of one of the conditions of tying. The case of package licensing, the licensing of multiple items of intellectual property in a single license. So, and a group of related licenses together. So, this will be tested, this must be tested under the purview of tying arrangements and licensing of products conditioned on the acceptance of the license of another, not separate products. So, you can only accept these licenses at a time or together. So, then in that conditions, in such situations, and this must be tested pass the test of tying. So, usually the package licensing is supposed to promote efficiencies in the market, must have a pro competitive effect, but if it does not have a pro competitive effects on the market, it will come under the tying arrangement and consequently violate the Sharman Act and the Clayton Act. So, the famous case of International Salt Company versus United States, the 1947 case, this was one of the first cases where the tying was discussed elaborately by the US courts. Here you can see that the salt was mostly the distributed by this International Salt Company, and the two type of, and they tied most of the machineries used for the utilization of salt products. So, they own machines as well as the utilization of salt products. So, one such machine was a lixiviator, which dissolves the rock and salt into the brine used in various industrial processes. So, one is lixiviator and the second one is saltomat, and saltomat which injects the salt in the form of tablets, and also this is mainly used in the canning process, in the canned food, in the canning process. So, it means one is patented and the another one is non-patented items. So, this can be only purchased together. So, the International Salt Company sell these particular products only together, and it was held that in 1947 itself it was held that this is the violation of section 1 and of the Sharman Act and section 3 of the Clayton Act by the courts at that point of time itself. So, the International Salt Company's case still it holds a valid decision in the United States, and with regard to the tying agreements. This is one of the famous judgment. Then we comes to the we will come to the another concept of block booking, and block booking, and which happens in the we can say that in the in cinema. In India also we can see that there are multiplexes which shows cinemas, and these multiplexes are owned by the different groups. So, it is very this United States was Paramount Pictures in 1948 case, and here also the same thing happens. So, if Paramount Pictures one of the still one of the biggest the producers of films, and the license the licensing practices and the licenses offered is in such a way that you have to purchase all the films, all the movies of the Paramount Pictures. It means that some pictures may be very good, but you are forced to purchase the pictures which are not so good, may be running or may not be running. So, here the exhibitors have the license, it is a group features. So, that means you have to know the way you have to take all the pictures produced by Paramount Pictures for a period of time during the contractual period. So, here it is a copyrighted pictures, mostly the copyright. The copyrighted pictures which must be taken and exhibited in order to secure the first. So, here high quality films are also licensed, but you are forced to the exhibitors have to forced to take a inferior one. So, it means that it is nothing but block booking. Block booking is nothing but you are forced to take an inferior quality film, you are forced to show an inferior quality film in your multiplexes along with a good quality movies, even though you do not want to show it, because otherwise you are not going to get a license for the particular movies. So, the court also said that this kind of block booking is also a violation of the Sharman Act. And again, here you can see that this is something different from what we discussed earlier, that is a tied product and a tied product, one product is tied to the other one. Here actually there is a component of coercion. Coercion is in always is an ingredient, a non separable ingredient of tying claim, and you are forced to take one which you do not want to take. And block booking compel the theatre owners to accept movies that they doesn't want to show. And here the actual coercion is an indispensable element of block booking violation, which is ultimately the violation of the Sharman Act and the Clayton Act. So, it is absolutely the block booking is an anti-competitive conduct, considered to be an anti-competitive conduct. And because there is a price reflection of tying and price discrimination, because one movie may be priced very high, but you are ready to pay a higher price for a good movie, but you are not ready to pay for another movie, but you are forced to take along with this highly valued high quality movie along with that. So, this can be so definitely there is a reflection of tying between a good quality movie and a bad quality movie. So, this will be considered as tying. When we come to the softwares, I already mentioned about the Microsoft case, Microsoft in the US as well as in the EU case, which is going to be discussed elaborately in the coming classes. So, here you can see that software, everybody knows that for example, software in India is non patentable, but in the United States it is patentable. So, the most of the companies like the huge companies, IT companies like Microsoft, Intel, all other companies own thousands of patents on softwares, and other jurisdictions like in India, the softwares are protected under copyright law. And here the copyright component, which we will discuss, the intellectual property component, that is the copyright vis-a-vis the softwares. In this particular case, that is the Digidyne Corporation versus Data General Corporation in the 1984, and it is a clear case of tying, that is the product is tied with service, the product is tied with the service. Here see here the General Data General Corporation and the refusal to license an operating system which was used by them in CPUs, Nova CPUs, that is the Nova operating system. So, if you purchase the Nova CPU, then only you will get the software, otherwise you are not going to get the softwares. So, the court said that this is nothing but the tying arrangement between the machine as well as the software, which is the violation of section 1 of the Sharman Act as well as section 3 of the Clayton Act. So, here if you purchase if you want to purchase one particular machine, then you are forced to take the software, or other way around, if you want to take for example, Microsoft operating system you want to purchase and put it in your machine, but you have to purchase the software as well as the machine from me, then only I am going to give you the license. So, the court very clearly said that this is the violation of the competition provisions. Here the operating system is clearly tying product with the CPU, and it is a tied product. Here you can see that there are two separate products, and purchase of one, that is the tying product and the tied product. So, there are two products are there. And secondly, the market power which we already talked about, market power of the tying product is also is very important. So, if you have the if you want the software to be there in your CPU, you have to purchase CPU from me, that is the condition. So, here economic power with respect to the tied product is also important. And then again, so substantial amount of commerce in the tied product, that means the software is tied with the CPU. So, there is definitely the substantial amount of commerce. So, whatever you want to sell, the number of softwares, the CPU also will be sold. And another very famous case is the Seagull versus Chicken Delight. And I have already said that the pictures have the copyright of, have the original owners have the copyright of these pictures. And the Chicken Delight is always is a famous brand, and have also the shops always in many parts of the United States. So, here they have franchising, the Chicken Delight have franchise all over, lot of shops. Chicken Delight have all of shops with a standard form of franchising agreement. So, the condition which the Chicken Delight put at that point of time is that the all franchisees should purchase the cooking equipment, certain dry mixed foods, and that is specifically trademarks bearing packaging exclusively from Chicken Delights as a condition of obtaining the trademark license. So, here the condition is something different when we compare to a software, or one product is tied with another product. Here there is a service, there is a product, there is a trademark, because always trademark contains reputation of the company. Here there is one company, Chicken Delight. If you want to get franchise of my brand, my trademark, if you want to use my trademark, then you have to purchase certain cooking equipment from me and certain mix or this packaging from me, then only I am going to license it to you. This is the condition, and here the situation is something different. Here the contractual requirement constituted certain requirement of purchasing certain equipments from me. So, my argument is that these equipments are necessary for keeping keeping the not only the value, the reputation of the product or the quality of the product depends upon these cooking equipments. So, here the products, as I told you, the Chicken Delight name, symbol, operation. So, definitely they have the economic power, and but it is alleged that the all franchisees alleged that these are tying arrangements. Why should I purchase all the cooking equipments from Chicken Delight? So, these are arrangement. The question is these arrangements whether justified or not. And here in this particular case, all the franchisees filed a class action against the Chicken Delight. So, the possible defense of Chicken Delight was the essential component theory. These equipments are essential to keep the quality of the product in order to use the trademark of Chicken Delight, essential component theory. If they are if they can prove the essential component theory, these are essential to keep the quality of the product, then the argument of tying is not going to serve. The tying arrangement is not going to be justified. The tying is going to be justified in the case of essential component theory. But the question is again whether they can compel the companies like whether it is Kentucky Fried Chickens, KFC can compel the franchisees to purchase equipment from them. I would say that definitely the KFC, whether it is a Chicken Delight or it is KFC, and they have certain equipments, trade secrets. These equipments or fryers are necessary to keep the taste of the food, or maybe that equipments are a necessary component of the reputation of the product, necessary component of the quality. So, then it is justified. So, the tying is not going to serve, and I can see that. So, you cannot claim that the sale of car along with the tires are tying. So, tires are essential part of a car. So, without tires you cannot run a car. So, if you can prove that these equipments are necessary part of the other product, then the argument of tying is not going to convince, not justifiable. So, again the other question is leg shoe and the right leg shoe. It is only shoe, there is no left leg shoe or right leg shoe, there is only shoe. Two shoes are necessary, single component. So, the question is these are single component or different components. So, whether these are aggregation separable items or not separable items, whether the functions aggregation can be happen or it can be separable. So, the amalgamation of products can happen or segregation of products can happen, but the question whenever the amalgamation happens or segregation can be happened, again the question of tying comes. So, the justification is very strong. If it is a very strong justification of tying, that is the theory which we talked about, essential component theory, if you can prove, and then definitely the argument of tying is not going to be is there, but it is going to be justified. So, as I strongly believe that the Chicken Delight or whether it is KFC or the company can prove the essential component, with the help of essential component theory, they can compel their franchisees to purchase that particular equipment from them, because I do not believe that this the reputation, because this reputation of the product, especially the food products, are very important. So, but if you can prove that these are separable items, then the argument will sustain. The teledirect case which we already talked about, 1997 case, the selective refusals by the respondents to license the trademark constituted an abuse of dominant position. But whether it is well within the legal bounds, whether I have any right to refuse to deal with anybody, this is the question, and definitely we will see the refusal to deal in the next classes. And here in the Eastman Kodak case also in 1992 case, here the again tying, very strong tying comes up, and the seller conditioned the sale of one product or service on the purchase of the second one. Then the second condition which we can see that the two products or the services are in fact separate and not parts of a single product, because if you sell the product along with the post sale services, these are separate product, not a single product, separate product and service. Then again the seller has, so again you can see that the seller has sufficient power in the market for tying product to enforce the tying, that the tying is affected a substantial amount of commerce. So, the tying should affect the commerce as well. If it is beneficial for the market, then the argument of tying is not going to sustain. In this the famous case of the ice cream case, which is known as Care versus Baskin Robbins Ice Cream Company, here also the question of the franchising comes. These companies are always insist that they should only use our products, and for example, if you closely look into this particular case, they operate in 3 levels, because this Baskin Robbins is a world famous brand of ice creams, and they franchise, second they operate themselves, and thirdly you can see that the second a huge number of manufacturers, 8 independent manufacturers, all of them are licensees. Then the third category is the franchise stores owners. So, that is that there is a condition that these franchise store owners will only purchase ice creams from their area franchises. That means, geographically they divide the market. So, per se geographically dividing the market is a violation of the competition provisions, but here again the company, as a policy of the company, they divided into they divided their business into three parts. So, their own showrooms, and they make the ice creams, and secondly there are 8 independent manufacturers which are the licenses of the company, and then franchised store owners who will purchase ice creams only from these particular manufacturers, and that also on area wise. So, the question is whether this violates in Sharman Act. So, because they said that it is the product ice cream is closely tied with trademark. Here we have to very closely look into the principles of tying and tied product. Here the allegation is that the ice cream, the product is tied with the trademark. So, whether these are inseparable, I do not believe that a particular product is separable from its trademark, because the trademark is very closely related with the reputation of that particular product. So, if is Baskin Robbins ice cream trademark cannot be separable from that particular products. So, here the franchisees were failed to establish that the Baskin Robbins ice cream products are unlawfully tied with the trademark. The trademark is non separable from that particular product, because always when it comes to the quality of the product and the trademark, it contains many other things than the two products. It contains the reputation and quality of that particular product and trademark. So, we talked about product and product, we talked about product and services, we talked about one product with in the case of softwares, we talked about hardware with software, we talked about products with the trademarks, and also we can see that all these cases there is inseparable tying. The court said that whenever you try to tie one product with the other one, it definitely affects the market. The only question is whether it is justifiable to the extent of tying and the tied product with certain specific conditions which we looked into. But the agencies, the competition authorities always consider that tying and tied product which is going to affect the market is in violation of section 1 of the Sharman Act and section 3 of the Clayton Act. And in some of the cases in the next classes, which we will see that how the market is responding to this kind of activities. So, in conclusion, I would say that whenever there is tying two products selling together, when one product is connected with another product or forced to purchase one product along with the other product, then definitely the competition provisions will come into play, and the courts amply said that, held that these are violation of the competition provisions. Thank you. In the next class, we will look into some other component of the intellectual property versus competition law.